Hi, my name is Goldman. I'm an attorney with Goldman Associates, and I'd like to talk today about a child custody issue and how it works in same-sex divorces. You know, in Michigan, before same-sex marriage was permitted, and you always had a mother and a father who were having a custody battle, there was a presumption in a marital union that the parties shared in the custody rights. Now it could be modified. There could be a reason to give one person the custody over another, but at least the law paid lip service to the notion that husband and wife started out equally, and you went from there. And maybe somebody under the custody guidelines was able to show that they are a more suitable custodian than the other, and there would be hearings about that, and that would be it. What happens now that the state of Michigan has allowed same-sex marriages? Well, now what's happening is you get same-sex marriages. You've got situations where either children are born naturally or they're adopted, depending on the genders, and then a divorce. Now what happens with the custody? Well, the legislature was very, very wise in making their decisions of custody and making the rules to not necessarily be gender-based, but to be best interest of the child based. So if the rules were strictly gender based and one parent always got the gender bias and the benefit of that, like in the 50s and 60s when we saw that the moms always seemed to get custody, and there was some notion that, amongst the judges that the women were just a better custodial parent. If that were the case, we would have quite a problem in a same-sex marriage where maybe you have two women or two men. How do you determine who's the most suitable one? But as it turns out now, Michigan has basically 12 guidelines that it uses to determine what's in the best interest of the child. Those same guidelines are analyzed whether it's a same-sex marriage or a more conventional marriage. In that situation, the court is going to determine whether or not it's in the best interest of the child to go this way or that way. So it really doesn't matter if it's a same-sex marriage or not. The court is still going to go through the guidelines. The court is still going to make determinations. Both parties are going to start out presumptively equal in terms of the custodial rights. And then the court will do its analysis to make these determinations. And the attorneys who are handling these cases will be submitting proofs, filing documents, cross-examining witnesses, bringing all sorts of evidence that they can to establish what's in the best interest of the child based on the guidelines. And that's going to be the same case whether it's a marriage of standard format or a same-sex marriage. If you have any questions about that, reach out and we'll be glad to help you out. If you found this helpful, please like, comment, and share.